Bonjour, good afternoon. You're very welcome to our webinar, Multi-Unit Developments, a practical overview of key governance and legal topics. David Rouse is my name, Multi-Unit Developments Advisor with the Housing Agency. Thank you very much indeed for joining us on this webinar. We have a very large number of registrants that are kindly joining us this afternoon, and as they're logging in, we will run a quick poll just to get a sense of who is joining us here this afternoon and the audience composition. We have a number of polls to make this session today engaging. We have 3 in total, so we'd ask you to please participate with the assurance that participation is anonymous. So when you vote or you express a view through a poll, you won't your name and so on won't be recorded. So we'd ask you to please indicate from the options available on the list in front of you, the number of options as to who you are, who's joining us this afternoon. So it's helpful for us to know the composition of the audience so we can tailor events in future and understand who's attending. So the options are OMC Director, AHB Local Authority Personnel, Homeowner, Renter or Tenant, Property Management Agent, Construction Property Professional, so Developer, Architect, Engineer, QS, etc. Are you in the accounting finance space, or are you in the legal sector, or are you someone who falls into none of those categories? So hopefully we've captured all the various audience participants there, and we'll keep that poll running for a number of more seconds while people are logging in. We'll give people time just to come in on the to come in and log in while they're arranging themselves. And we hope you're having a nice afternoon today. If you're having your lunch, I hope you have a nice sandwich or a nice coffee in front of you. And if you're not, well, we promise to have you concluded by 1:30 so that you can go and get a nice lunch, and maybe hopefully it's sunny where you are and you can get outside and enjoy the spring sunshine for a time with your lunch, and maybe a walk as well with it. So look, I'll run that survey for another couple of seconds. Thank you all very much to those of you who have participated. Again, anyone joining just in the last number of seconds, please do let us know who you are. The participation is anonymous, so we'd be grateful if you could let us know who you are. That would be great. So I'll have run that poll now for about 2 minutes. So I'm going to end it now, and with thanks again to everyone who participated in it. Thank you very much indeed. And I'll just share the results of the composition. So just so you get a sense of who's with us today. So 16% of you are OMC directors, 14% are in the AHB or local authority sector. We have homeowners, we have some renters and tenants, we have property management agents, construction professionals, about 16%, accounting finance, 5%, contingent from the legal sector, 15%, and other 5%. So thanks indeed for that information, very helpful to us in future. So again, those of you who maybe just logged in late, David Rouse is my name, Multi-Unit Developments Advisor with the Housing Agency. We will do some housekeeping before we get into the meat of our session today. So we've just done poll 1, and thank you very much for that. We will have an introductory session on some current news and information on the apartments and multi-unit developments sector, both from a planning and a regulatory side. So that'll be from myself for 2 or 3 minutes. We'll then have our contributors, who I'll introduce you to shortly. We will then have a short time for a Q&A, and we will have a third poll and some conclusions and final wrap up. So we'd urge you to stay with us to conclusion to about 1:30, and we promise to have you finished up by then. Other housekeeping matters, the chat is enabled so that you can tell us if there's a problem with sound or vision on the session. So I'm joined by my colleague Graham Fryer in the background, and Graham will keep an eye on the chat, and if there's a difficulty with any of the technical aspects of the presentation. In terms of the questions and answer session, look, we've received a large volume of questions that have come in by email, and really and truly, in the time allowed, we'll get to those today. Feel free to contact us, mud@housingagency.ie, with other questions and queries. But in the time allowed with our contributors and with our presentations and other aspects of the session, it'll prove challenging to get to any live Q&A. But we do have some questions that have come in by email, and indeed, we might ask you to wait towards the end of our contributors' presentations, where you will, no doubt, many of your questions will indeed be answered in those presentations. The session is being recorded for future use, so we intend to put it on our YouTube channel in due course, and we will send you out the slides that follow. So no need to chase us for those as we go forward. We should say that the information and material that we're delivering today is general in nature. You may have queries in relation to your own estate or your own specific OMC or multi-unit development, and there will be unique aspects and characteristics to those questions. So we would urge you to contact your property management agent if you have one, or your OMC solicitor for tailored advice in relation to those queries. That said, the principles and the material we will provide today will cover a lot of the issues, no doubt, arising for you. A little bit about the housing agency for those who haven't engaged with us before. Those are our offices on 53 Mount Street Upper. We work with the Department of Housing, Local Government and Heritage, with local authorities, approved housing bodies and stakeholders in the wider housing sector, with the mission to promote the building of sustainable communities in the country. So as promised, some news in brief from me on two main issues: apartment numbers news and some regulatory news. Just to give you some context about what's going on in the sector, what we're displaying there is some information recently released by the Central Statistics Office in relation to planning permissions for homes over the last 10-12 years. And the green line is apartment planning permissions, and you can see in recent years the increase in those. In terms of the detail of permissions over the last 2 years, the yellow or beige bars on the graph are the apartment proportion of planning permissions granted over the last period. And you can see quite clearly the significant proportion that apartments form of planning permissions over the last 2 years. So those are permissions. What about completions over the last 10 years? And again, the orange or yellow line, I suppose, in the middle in the red box towards the end of Q4 2022 is apartments. And again, you can see the considerable increase of rate of completions of apartments in the last 10 years in the country. To put those into percentages, the percentage of the number of new dwellings completed in the last 10 years is up 508%, but the number of new apartments completed is up nearly 2,000%. So it shows you the relativities in terms of apartments versus other housing typologies. And in 2022 alone, 9,000 apartments were built, were completed, which is up 79% from 2021. The number of apartments completed in 2022 was greater than 2020 and 2021 put together. 31% of all completions in the country were apartments, 17% in 2019, and amazingly, 75% of all homes completed in the Dublin area in 2022 were apartments. So again, it shows you the significant growth in the sector. There is that challenge and that gap in terms of apartments completions versus planning permissions granted, and in particular you can see in relation to apartments on the right hand side. And this is an analysis that was done recently by the Department of Public Expenditure and Reform, as it was then called, and I suppose there are policy initiatives underway to bridge that gap between permissions and completions. It's fair to say, I think, that the rise in apartment goes hand in hand with the parallel diminution in new dwelling size in terms of square feet and so on over the period back to 2011, and some illustrations there. For those of you attending from Cork, JBM typically stands for Jimmy Barry Murphy, but in apartments and in finance and in journalism, JBM is John Byrne Murdoch. a data analyst with the Financial Times, and he had some very interesting things to say and analysis recently in his article on St. Patrick's Day, and you can see it there. It might be of interest to you. You can look it up. The link is included. And some of the themes of which were brought through in a recent David McWilliams podcast. And again, these commentators will have their own views, but it was interesting to see the analysis on the left-hand side from John Byrne Murdoch of where Ireland is in terms of apartments and flats as a proportion of housing stock, about 9%. And on the right, you can see the residential densities of various cities around the Anglosphere, as it's termed. So those countries with English as the spoken language, or indeed an English-based legal system. So just some interesting background and some commentary that you might want to check out for yourselves. Many of you will be interested in the defects scheme that was announced back in January, and there's information on that on the Department of Housing website. They've published frequently asked questions document, and the establishment of that scheme will be subject to the legislative process over 2023. In terms of regulatory news, some quick updates from a company law point of view. You'll all know that the provision for company law and companies to have their AGMs online was extended to the end of 2023, where it's required and where your constitution doesn't provide for a virtual AGM. And as part of the public consultation process on enhancements to the Companies Act, the Department of Enterprise, Trade and Employment will be examining the implementation of that provision for virtual or online AGMs as a permanent provision. So that's an extract from a recent announcement on their website, and you can see in the box in red details in relation to virtual AGMs and the bringing in of that on a permanent basis. There was to be Sunday just passed a provision that PPS numbers, so personal public service numbers, were to be provided to the CRO in their filings of A1s, B1s and so B10s and so on. However, that exercise has been put on a slightly temporary pause. The CRO announced that in the last number of days, so it'll be taken up in future shortly, as they indicate on the new information on the slide there. But in the meantime, if you would like to familiarise yourself with the detail and the rationale for that, there is guidance on the CRO website and indeed on the website of the Corporate Enforcement Authority. So very useful guidance on the provision of PPS numbers in CRO filings when that ultimately comes into play shortly. But in the meantime, what is on the CRO website for registering new owners management companies under using the form A1, and indeed for existing owners management companies, is that they indicate that they are indeed OMCs. So this is an exercise to try and get a handle on the size of the sector. So if your agents or if your directors filing your B1 for your OMC, please ensure to tick that box in the filing process. Some other guidance that was recently issued by the Corporate Enforcement Authority might be helpful in terms of financial management for OMCs and monitoring the financial position. So I've included those there. And again, we'll email the slides around, and the links are included there. Some updates from the PSRA. You'll all know that their new letter of engagement is in place since last October. They have issued some new guidance in relation to their own role and the investigation of complaints, and you can look at that perhaps after the session and their particular provisions. And finally, just in terms of a regulatory update, Tailteann Éireann is now the body to which you will be submitting your deeds of transfers of common area. So Tailteann Éireann now is made up of the merger of the Property Registration Authority, the Valuation Office and Ordnance Survey Ireland, and that's their homepage there. So that's enough from me. On to our contributors. We're delighted to have with us today Henry Murdoch. Henry is a retired barrister, a chartered engineer, and he's author of the recently published book, Apartment Living in Ireland, a practical handbook for owners, OMCs and management agents. Henry has recently chaired an OMC board of directors, and he's the author of Murdoch and Hunt's Dictionary of Irish Law, now in its 6th edition. David McCourt is Director of Asset Management and Property Services at Cooperative Housing Ireland, one of Ireland's largest approved housing bodies. David began his career as an officer in the Irish Defence Forces, and since retiring has held a number of property and facility management leadership roles. And Dave is also a chartered engineer, and he's a member of Engineers Ireland. So delighted to have Henry and David with us this afternoon. And the meat of the session, key governance and legal topics. we will run a sort of a call and response, if you like, format today, where Henry will give his overview of the key governance topics that we have listed there. So we've grouped them. Henry will deal with the AGM and the annual report, and Dave will give his practical experience from his in-depth involvement in OMCs and multi-unit developments in the AHB sector as an owner, indeed, where CHI are acting effectively as agents in some estates as well. So we'll get a rounded picture both from the legal technical side, if you like, and the on-the-ground practical side. So insights that will assist you and help you in your day-to-day role, be it as a director, an agent, a lawyer involved in the sector, or whoever. So we look at service charges and sinking funds, and we look at house rules and proxies. So we'll take the two topics together, and we'll hear from Henry first, and then we will hear from Dave with his observations. So I'll stop sharing now, and I'll hand over to Henry. So Henry, thank you very much. The floor is yours on the AGM and the annual report.
David, thank you very much for that introduction. Could I just say at the start, as you mentioned, I've been the chairman of an OMC for 2 years recently, and I have been an owner of a number of apartments. So I've had a lot of interaction with managing agents and a lot of interactions with the AGMs. And I've had discussions with other chairpersons, and I've done limited research through the apartment owners network. So that's where I'm coming from. And so some of the examples I give of where we could improve the operation of AGMs and annual reports, it comes from that experience. So the first thing I'd like to say is that the AGM, while to some people it's a kind of a pain in the butt, for me it is the most important meeting of an OMC, and it retains very important decisions. When you think of it, because owner management companies are not just subject to the Multi-Unit Developments Act, commonly known as the MUDS Act, but so they're also governed by company law. And you've got to keep remembering that, because the board of directors are given a virtually total responsibility for running an OMC, but there are retained responsibilities that are kept for the AGM, so that the owners eventually guide the overall operation of the company. And that's why the AGM is very important, and it must be run in a very professional and organized manner. Now, the first thing I would say is that it may seem trite to have to say it, but there should be a formal signing in for every AGM, where people sign in against their apartment and they're given voting papers. Now, that doesn't happen always. I have been at AGMs that have been run less formally than my local golf club or local GAA club. And when I've mentioned this to individual managing agents, they've often said, "Ash, we'd never have any trouble at our AGM." But if you don't have those procedures in place, if an issue comes up where someone demands a poll, and it only takes 3 members to demand a poll, you will have to have a formal vote. If you haven't issued voting papers, you'll have to march everyone out of the meeting room and have them all come in and sign in again and give them voting papers. And then everyone who's entitled to come to a meeting won't necessarily have a vote, because members who are in arrears in their service charge or sinking fund contributions are not entitled to vote. And they will not be given a voting paper, but they are entitled to come to the AGM and to be heard. And I have been at many AGMs where that has happened, where people have come who wanted to speak, but they were in arrears and did not have a vote. And that is their legal entitlement. So that's the first point I'd like to make. The second point is in relation to managing agents. I think it's important to emphasize the managing agent is, in my mind, the technical advisor to the chairperson at the meeting. And in many cases, that is done very, very, very well. But I have seen it on occasions where the managing agent takes over the chairmanship of the meeting. Now, I understand that used to happen in the bad old days when apartment dwellings might have been managed between the property developer and the managing agent. But I have seen it happen where a new chairman, in this particular case, a chairman told the meeting, I'm very inexperienced. This is my first meeting as a chair. I'm going to ask the managing agent to chair the meeting. And the managing agent got up and immediately started to chair the meeting as if he had done it before. But it was pointed out to the managing agent that this was in breach of the constitution of the company. And in fact, it wasn't good corporate governance. And that the chairman, the new chairman, was advised that with the help of the members, he'd be able to get over the barrier of his first chairmanship with the help of the members. And in fact, that's what took place. But I've also seen it happen unintentionally, where rightly the managing agent has been asked to present details on a subject that is under discussion at the meeting. For example, the financial report, or indeed the annual report, which I'll be talking about later. And the managing agent presents on that particular topic. And because the next item on the agenda happens to be tied in with that particular thing, the managing agent continues on and starts to chair the meeting. Now that it's up to the chairperson, in fact, to stop that, but it shouldn't. The managing agent should be aware that he should hand over, he or she should hand over to the chairperson. The next matter that I wanted to bring to people's attention is in some OMCs, the OMC puts requirements on members that have no justification in law and in fact are poor corporate governance. In one AGM that I attended recently, a notice was sent out to all the members and rightly used very strong language in relation to proxy forms and said that the proxy form must be delivered by such a date, etc. But then it followed with a statement, any queries regarding the financial statements must be submitted in writing on or before a certain date to the managing agents. Now, there's absolutely no requirement in company law that you must give written notice of questions about the financial statements. And in fact, that is contrary to good corporate governance. Of course, what should have been said was, please give us notice if you can before a meeting in order that we can give you a very complete reply to your questions. The next item I wanted to mention in relation to an AGM, because there are some 8,000 OMCs in the country, and we don't know what's going on in them. You will know about your own AGM. But one thing that has come to my attention is there seems to be some misunderstanding as to what needs to be approved at an AGM. And usually meetings start with the minutes of the previous meeting. Now, they do not need to be approved by the AGM. It is quite in order that if there's a very clear mistake in the minutes, that this should be pointed out, like if people had given apologies and it hadn't been noted or something like that, a factual matter. But there is no need to approve the minutes of the previous meeting. They are approved by the board of the company. And the matters that require approval are if there are new house rules, the service charge budget, the sinking fund contributions, and the election of directors. And another area of a certain lack of knowledge, I believe, is in relation to the percentages of approval that are required for various matters on an AGM. There will be a slide on this, which we will discuss subsequently, and it will be sent out to the various, to the people who are attending today. But suffice to say that the percentage of approval varies from 25% plus, which is very unusual in company law. It's a special requirement under the MUDS Act for approval for the service charge budget, which determines the service charge for the year. May seem a bit undemocratic, but it has a good legal basis on that this is the lifeblood of the apartment complex. And if there were a lower bar, it might make the running of apartments very difficult. And that goes to 100% under company law for a written resolution, which we can deal with subsequently at the end of this talk. Another aspect is in relation to a chairman's statement. It is common practice in companies generally that the documentation that goes out with an AGM has a chairman's statement with it. And that gives an opportunity for the chairperson to outline how the company is doing, whether it's in a good financial state, what kind of difficulties it's facing, the challenges that are there. It can guide the participants through the documents that are going to be dealt with subsequently. And it is of terrific value to people who cannot attend the AGM because they get an overview of how their company is doing. I would be very strongly in favor of that. And if I could move now to the annual report. The annual report, as I mentioned, is considered at the AGM. It doesn't have to be approved. It has to be considered by the AGM. It's generally prepared by the managing agent, and it is required to have certain specified information, and they are all laid down in the Act. Now, the one thing I'd like to say about the annual report is I have seen very, very good ones, and I've seen very poor ones. The poor ones are ones which are not a complete document. The annual report should be a document on its own. Here is an example of if you can see, you don't need to see, except that I just want to say that I'm quoting from this document, and it's a real live document, only of recent origin. And it for example, when the Act says that you have to give a statement of the income and expenditure, and one would expect to see in an annual report that it would have in it the expenditure was such an amount, the income was such an amount, and we had an excess, or we didn't have enough money to run the place. But in this particular report, it just says income and expenditure account for such a period. Please see attached accounts with the notice of the meeting. There's a similar comment in relation to the annual the service charge and the sinking fund. And right throughout the document, you need to go to other documents in the board pack to find out what's happened. So the first thing is the annual report should be a complete document in itself. Also, one of the provisions in it is that it must include the details of the insurance. And the law says that you must give the details of the insurance. It doesn't say so you have to tell, you have to be told what cover is provided, but the law doesn't say that you have to describe any changes in the cover. And that can lead to a situation where, in an example I had recently, where the public liability was stated as being 6.5 million euro, but what was not stated was that it had been reduced from 13 million to 6.5 million. Now, that's not required. Changes are not required by the law, but under good corporate governance, you should provide the information that gives the owners a full picture. So finally, before I hand over to Dave, the other point about the annual report is it is required to be provided a minimum of 10 days before the meeting at which it will be considered. Now, this is at variance with the 21 days under which notice has to be given with the meeting. And what happens in practice, if you comply with those exactly as the law states, it means that the AGM documentation goes out 21 days before, and the annual report, if you wait until that 10 days, goes out 10 days before. And yet you're issuing proxy forms that ask people to provide someone for a proxy if they cannot attend, to deal with matters that will be decided, and the detail of those matters are in the annual report, which you won't get until maybe 11 days later. So I'm suggesting to people that they can comply with the law by issuing the annual report at the same time as they do with the rest of the AGM pack. So with that, I'll hand over to Dave.
Thank you very much, Henry. I suppose really just to set the scene in terms of kind of my input at this presentation, really Cooperative Housing Ireland experiences that we currently own or manage in and around 1,500 apartments across the country. So that means we have experience in terms of kind of being members of OMCs, directors of OMCs, or in certain instances acting as a proxy on behalf of a senior landlord in terms of some of the properties that we manage. And really what I'm kind of doing is kind of giving a practical experience of kind of the points that Henry is bringing out there, and relaying experience of our regional housing managers and our asset managers in Cooperative Housing Ireland that act as directors on boards. So just to kind of kick off really with Henry's first point, which was around the AGMs, and Henry alluded to the fact that, OMCs and boards of directors, the inclination is to allow the managing agents to actually chair and drive the meeting. But, in reality, that's because they organise the AGM on behalf of the OMC. But, really what it comes down to is correct and appropriate preparation for the meeting from the board of directors and the chairperson. And with the appropriate kind of preparation, they should be capable of leading the meeting. And we found that that's best practice for us where we do act as directors on OMCs, and it's really incumbent on the board of directors to be prepared. And in doing that, the way we found that works best for us is by having a pre-meeting well in advance of the AGM to war game out the AGM, how it's going to work, how the agenda is going to work. But to enable us to do that, we need to have the AGM pack ready. And that kind of comes back to Henry's point around having a complete AGM pack and also having a complete annual report, and having all that information available for the directors when they sit down together to plan out that AGM. So that means they have to have the AGM pack. They should have the audited accounts. They should have the auditor's report, the budget for the upcoming service charge, the sinking fund, and any resolutions that are going to be presented at the AGM as well. And the directors also need to know who are the directors that are stepping down, and many new directors need to be appointed to the board, and people that have expressed interest in joining the board of directors. And that should be all kind of talked about and planned out beforehand. And if that's done correctly, well, that means that the chairperson is in a position to actually chair the AGM, and he's not leaning on the property or the managing agent to do that. Now, that doesn't remove the ability for the OMC or the board of directors to lean on the managing agent to organise the AGM or to get the documentation ready for it, but they need to understand what's going to be presented at that meeting. Henry talked about the auditor's report being included in the AGM pack and the complete auditor's report on that. One of the things myself and Henry talked about beforehand was perhaps even the auditor attending the AGM to actually give a report on the audited accounts. You know, it would be best practice. It's not something that we see happening very often, but in reality, you know, the auditor's report should be included in full, including their commentary on it. If you are intending the auditor to turn up at your AGM, that is something that you need to include in the scope of their engagement, and it also needs to be budgeted for as well. And like with services charges as tight as they are, you know, that needs to be budgeted for well in advance. So that's really, you know, as regards kind of AGMs. As regards the annual report, you know, it is around completeness of that report, you know, and that the annual report should be finalized well in advance. You have that dichotomy between the 21 days notice for the annual general meeting versus the 10 days for the AGM. Where we have influence on OMCs or where we are directors, we would try to ensure that everything goes out at the same time. And again, the directors need to have familiarity with the content of that report. Henry talked about kind of ensuring that the report is complete. You know, one of the things that we find works well for us is that we would append the documents to the annual report rather than sending them out as separate attachments, so that, you know, you could see Appendix 1, but it's all included in the one report rather than someone actually having to go from document to document. You know, and that's really it from my perspective on that. Those two initial points. I think, David, you're going to run a poll then on AGMs now at this point, I think.
That's great, Dave. Thanks very much. I'm going to run a poll here for those in attendance to rate their annual general meetings. So if you could, again, this is an anonymous poll. So if you could rate your experience of annual general meetings, we have excellent, good, fair, poor, or very poor. So just to get a sense from those of you who are attending, to get a sense of what your experience is of the AGM. So about nearly half of you have voted now. So again, it'd be great if you could give us your views, and it's useful for our contributors indeed as well. I'm just keeping an eye on the clock as well. We're coming up to 1:05, so I suspect that we'll get a very limited time on our Q&A later on with Henry and Dave's contributions to come. But that's about 62% of you have participated. So I'll close that poll and I'll share the results. And you can see that 13% of those who responded had an experience of an AGM that was excellent, 39% was good, 35% was fair, 8% was poor, and 5% was very poor. So I suppose fair is what it is. So there's plenty of scope for people to move up the ranks, if you like, and for better experience. And hopefully the insights we're delivering today will assist with that. And to that end, I'll move on to Henry's next two topics, which are the service charge and the sinking fund. And we're just coming up on about 1:10. So Henry, over to you on that one. Thanks very much.
Thank you, David. I'm not sure if you have switched over to me.
Yes, go first. No problem.
Yeah. Yes. In relation to the service charge and sinking funds, just a few points to make. Number one, the sinking fund and the service charge budgets must be included in the annual report, the proposals for them. Now, I have had experience where in the one that I showed you of the annual report, there was no mention of the service charge in this report or the sinking fund. It was handed out at the meeting. Now, that's just not proper. It's not in compliance with the law. It's very poor corporate governance. Now, I only hope that this applies in a minority of OMCs, but it is very, very important that it is included in the annual report, because how can people consider it properly unless it is? The second thing is that there appears to be a tendency to produce the service charge as comparing a budget from one year. If you can see this, there are two columns here in this one. And in another one, this is all relatively recent AGMs. There's another one, 2 of them. And in both of them, they have the budget for the year, the previous year, and the budget for the new year. Now, I have mentioned this to some managing agents, and they have said, oh, but of course, we consider the actual as well of what has happened, or if we don't have an actual, we do a projection of what the projected year outcome is of the current year. And that's what we base it on. Well, why I would say to that is that if you are using information that you're not giving to the members, that is not good corporate governance. So what should happen is there should be, in your service charge budget being proposed for the year, there should be 3 columns. One should give the prior year budget. The second one should give your projected actual expenditure for the year end. And then it should show the budget for the new year. And therefore, it takes into consideration what has actually happened during the current year or is projected to happen. That's probably the most important thing to say about the service charge. And in relation to the sinking fund, I think that this is an area that requires an awful lot of reform by the way OMCs operate. There is a large amount of evidence, and I'm just quoting from the Society of Chartered Surveyors, who did a survey in 2018 that reported that 73% of OMCs acknowledged that they did not have sufficient sinking funds to provide for their development. Of course, the sinking fund expenditure, it should be based on a building life cycle report. But in the absence of that, I have always had the view that if you have less than 1.25% of your annual income for your service charge, you're probably not providing anywhere like enough money for the future. I've experienced myself in some apartment developments where the sinking fund has been collected from about 30,000 euro collected each year. It ends up at the end of the year with 10,000 euro in it. And that has been consistent over a number of years. There are other apartment developments in which I've experienced that have more than 1.5% of their annual service charge intake in their sinking fund and are relatively comfortable. But the sinking fund should not be used for a current year normal expenditure. And I must say that in my view, is being gravely abused. Now, I would implore on managing agents to take, because I believe that they have a significant role in relation to this. Now, the guidance from the PSRA to managing agents is that if a managing agent is aware of abuse, they should address the situation as soon as possible with the board. I think that should be hardened up to being that they should, in fact, go to the auditor and tell the auditor that they have concerns in this matter. I think it is something that the OMCs have got to face up to. I think there is a ticking time bomb for OMCs in their failure to deal with this issue. And it's a recurring problem unless it is dealt with. So over to Dave.
Thank you very much, Henry. I'm going to keep moving on this and just very briefly address the kind of the service charges. I would 100% agree with what Henry has said there. It has to be based on historical spend, and it also has to be based on reasonable, predictable spend as well. So remember, not every item that you're required to service or maintain requires an annual service. It could have an interval of 5 or 7 years. Periodic inspection reports or electrical inspections on landlord electrical distribution systems would be an example of that, but it's not due every year but might have to be budgeted for at a regular frequency. You know, not to be trite, but you know, your service charge is a lot more than just kind of, you know, the grass cutting and the cleaning of the common areas. There are a lot of statutory, regulatory, and legal obligations the OMC have in terms of kind of the systems that are installed in landlord common areas. You know, those systems are becoming increasingly more complex and technical, and you know, now extend far beyond just maintaining your fire alarm and your lifts. You know, we're seeing more and more kind of residential sprinkler systems, and while the servicing requirements and the certification requirements on those aren't as kind of onerous as on commercial buildings, they do need to be serviced all the same. You know, fire alarms are becoming more and more technical as well, and while your fire alarm company will service the system and the inputs and outputs to it, for example, the use of our AOVs that are linked to the system may require to be separately serviced, and that requires to be budgeted for in your service charge. And really a good guide for this is the Fire Safety Guide for Building Owners and Operators, which was published in March 2022 by the National Directorate of Fire and Emergency Management, published by the Department of Housing. And I think that's a good reference for any OMC or director to understand what their responsibilities are as a building operator. And that deals specifically both with commercial buildings, but also with residential buildings. So I think that would be the first stop for kind of OMCs and directors to understand their responsibilities, and then understand why service charges do need to be set to ensure that you're meeting your statutory and legal regulatory compliance when it comes to servicing these items. You know, energy management, just to touch on it very, very quickly, you know, there is a lot of savings to be made there in terms of kind of ensuring that you're not needlessly wasting energy in your properties. You know, a lot of the low-hanging fruit around the use of LED lights has been kind of picked up on already, but it is ensuring that you're continually trying to address that to reduce utility costs. The sinking fund, I would 100% agree with what Henry has said. You know, if you are only paying your minimum amount of sinking funds in there at €200 per unit, it is not going to cut your life cycle component costs over 30 years. You know, just to look at kind of what we do in the AHB sector in terms of budgeting and forecasting for our life cycle contingency fund, you know, we should have 15,000 on year 25 saved up for a contingency fund for our lift repairs, you know, and on 40 years or 50 years, we should be actually budgeting for a full replacement of that lift. And I would hazard a guess that most OMCs are not kind of looking that far out and not kind of building up their sinking funds to meet those type of future needs. You know, I would recommend the services of a building surveyor to carry out a stock condition survey on your property or a survey on your property to give you those life cycle intervals, to tell you indicatively over 30 years when those components need to be replaced, and give you a very accurate 5-year window of year 1 to 5 as far as what's your most critical items to be replaced, and give you a budget for replacing that. I suppose just to echo what Henry has said as well, in terms of under collection of the sinking fund or a low sinking fund really means that sinking fund contributions in the future are going to have to be greater, or the OMC is going to have to levy the members to replace an component when it does actually fail unplanned. So really it is about planning to have a healthy sinking fund to meet the future needs of the building. And I know it seems a long time down the road in terms of kind of 30 years, but you know, OMCs need to start planning for that now. And that's really my few points on that. I think it's back to Henry at this point.
Yeah, I know that we're under time limit here, so I'll be very brief in relation to the house rules and proxy forms. I just say about house rules, very important function of an OMC, very important for the quiet enjoyment of the property. So if you have respect for your rules, show respect for them by not putting them up on an A4 size sheet inside the entrance halls. Produce a nice brochure like this. Give with nice photographs. If your apartment dwelling doesn't look very good, you can have nice photographs of the area, and put so that you show respect for your rules, and it can be useful for your owner landlords who want to rent a property. And on proxy forms, I would just say the proxy form is only complying with the law if it gives you the opportunity to tell the proxy how to vote on the resolutions that are before the meeting, the AGM, which essentially will be to do with the service charge and the sinking fund. And it's very important that that is done properly. And if you are appointing a proxy, don't appoint the managing agent as your proxy. It's putting the managing agent potentially into an invidious position. And think about appointing, if you're a landlord owner, think about appointing your tenant. I've attended some meetings of AGMs where the tenant of an owner has been the proxy, and they probably knew more about the apartment dwelling than anyone else in the room. Over to you, Dave.
Yeah, I'll keep this very brief as well on my side. So look, the house rules really are very important. It's about, you know, the comfort of living of everyone that's there. You know, as a landlord ourselves, you know, or acting as a landlord ourselves, one of the things that we make sure of is that when we give out tenancy agreements, that we do include a copy of the house rules with it. And one of the things that is worth considering is translation of those house rules into different languages of your tenants, and to utilize translation services to do that, to ensure that they're done correctly and accurately. As regards proxies, you know, Cooperative Housing Ireland as an organisation does act as a proxy where we lease a property from a senior landlord, and I think it is a very important thing to consider, you know, in terms of, you know, the insight that your leasee can provide in terms of acting as your proxy on the AGM, particularly if you have a good relationship with your leasee or with your tenant. And really, they're the main observations that I would have on those areas.
Thanks very much indeed, Dave. What I'm going to do now is, as Henry referenced earlier, is share my screen with some, if you like, guides or a summary of the key voting thresholds in relation to both AGMs and written resolutions. And I suspect, Henry, we're challenged for time, so I propose we don't go through those all in detail unless there's any particular ones you'd like to highlight.
No, I haven't seen this in this format. That's why I produced it in this format, because I think it shows very clearly what the voting positions are. And I think it's self-explanatory. The only thing I'd say is that the point of the 50% for adoption of the statutory financial statements, in fact, that doesn't have to be voted on. That can be taken as read because it has been approved by the board of directors. It doesn't require approval, but it seems to be common practice that people like to have it adopted.
And just there is a second slide there, just for completeness, in terms of written resolutions requires a 100% approval by all members entitled to vote, and then the audit point as well.
Yeah, and that can be very useful for a small development where you can get everyone to sign a particular resolution, and then there is information in relation to the audit. If you want to force an audit, it only takes one member of a CLG, a company limited by guarantee, to force the company to have an audit, but there is a procedure that has to be followed.
That's fantastic. Look, we've packed an awful lot into a very short session, and again, to say to people that the observations and the insights from Dave and from Henry are very important for those of you on the ground. And as both Dave and Henry have mentioned, it's important to bring into play your property management agent or your solicitor or your accountant or whichever professional is appropriate to the particular issue or question arising in your estate, so they can deal with the unique characteristics or the specifics of the issue that are arising and give you best advice in that context. We have had a couple of questions. As I said, there's a lot have come in by email and a lot have come in live while we've been doing the session. So we will follow up directly with our queries by email. But I suppose some of the dominating themes, Henry, that have come in are around maybe owners with a large number of properties in an estate, perhaps dominating a particular running of an estate. Any thoughts on that as an emerging issue?
Yeah, well, the MUDS Act is very, very clear that one vote attaches to each residential unit, and each vote is of equal value. So that's a key thing in the legislation. And it places owner management companies in no different position than companies. Large shareholders in a company can dominate the company. Now, I mentioned at the start that OMCs are governed not only by the MUDS Act, but also by company law. And there's a very important provision in company law. It's called oppression of a shareholder. There are regular comments in the newspapers of High Court cases where minority shareholders feel that they are being done down by a majority. And if in the case, the question that was put to us, it had an allegation that the dominant shareholder might have been using an inflated a service charge to drive the minority to sell their apartments to the dominant shareholders. If that were the case and could be proven, it could make a very interesting case in the High Court on oppression of a shareholder. Again, as I said, the OMCs have the benefit of the obligations, but also the protections of company law.
And some of the other questions, I suppose, have focused on maybe some of the key documentation, other than those that you've maybe mentioned already. So I think, for example, ownership of particular segments of properties. The head lease is very important in that respect, isn't that right?
Oh, yes. Well, complications can arise where you have properties that are made up of homes and of traditional houses, I should say, and apartments. And sometimes the disputes arise as to whether one side is subsidizing the other side. But there is a provision, and also then that can be affected by questions of the taking in charge of maybe the house units. And it does raise the question as to whether the problems can be solved by, in fact, dividing the one OMC into two OMCs. And the Circuit Court has power under the MUDS Act to, in fact, divide an OMC into two OMCs or three OMCs to deal with a particular problem. And that could solve these disputes.
Very good. Thanks indeed for that. What I'll point people to in terms of further resources and information that is available over and above the fantastic insights. And thank you very much. We can see lots of positive feedback coming through in the chat. Thank you very much for your responses and for your positive feedback. On our own website, there are there's a wealth of information that's available to you. Housingagency.ie. We have details of frequently asked questions, many of which would answer the queries that are coming through for us on the chat. We have a series of deep dive, if you like, training sessions on our YouTube channel. There's a link there and they cover the topics that are available to you there. We have 15 other webinars on various aspects of the sector, and again on our YouTube channel. Further deep dive reading, Henry's own book, Apartment Living in Ireland. Our own guide in the middle there, Owners Management Companies, a concise guide for directors prepared with Chartered Accountants Ireland, and Owners Management Company Law and Best Practice by Aisling Keenan. So lots of resources available to you. In terms of what else the housing agency has pulled together on our website, you can access a recent compilation of writing on various professional journals and media articles on different issues and topics in the sector. Our recent residential satisfaction survey during the COVID-19 pandemic has insights in relation to apartment living in particular, and the link for that is on the slides at the bottom there. We'll be holding outreach events later in 2023, and those are just some images of our sessions in 2022, last year. So keep an eye on our website, housingagency.ie, for those particular events. Our Housing Practitioners Conference is on the 11th and 12th of May in Limerick, and that will have a month's workshop. So those of you in the local authority and AHB sector are invited to come along to that indeed. And finally, I might just, as we come up to 1:30, I might just run our final poll, and we'd ask for your feedback in relation to today's session. So we've been very grateful to you. I know you've already given us some observations through the chat. So thank you very much indeed for that. But please do let us have your thoughts in relation to today's session. So we're very grateful to you for tuning in. And as people are voting, and again, this is anonymous feedback, so please feel free to give us your views. As we're concluding, as we promised we would, coming up to 1:30, we thank Henry indeed for his insights and observations on the legal and governance side of the topics considered. We thank Dave very much for his practical on-the-ground experience and his insights indeed from his colleagues. I know he spent some time engaging with them, so thank you very much for your assistance with that. From my own perspective, thanks very much to Graham Fryer for his assistance, my colleague in the background, in answering your technical questions on the chat, and indeed to my communications colleagues, without whom the session would not have proceeded as smoothly as it did. So I'll wrap it up there as we come up to just after 1:30. We say sorry that we couldn't get to all your questions. Indeed, there were just so many. We had such a huge attendance. I think we had about 540 people at the peak of the attendance. But we will endeavour to get back to you on the Q&A over email. A reminder that we will email around the slides, and a recording of this session will be available on our YouTube channel. So with that, I wish you a very pleasant afternoon. I hope you have a nice lunchtime, and thank you very much indeed for joining us.